XRP is entering a new level of development. How much money do you think this will bring to investors? Write answers in the comments. The U.S. Securities and Exchange Commission's lawyers have indicated that they would seek to dismiss all accusations against Ripple CEO Brad Garlinghouse and Executive Chair Chris Larsen. The SEC told the court in an Oct. 19 filing in S. District Court for the Southern District of New York that the parties engaged in its lawsuit against Ripple have stipulated to the dismissal with prejudice, implying that there was no need to schedule an imminent trial. The filing made no mention of the SEC's withdrawing its legal complaint against Ripple, which was initially filed in 2020. The SEC and Ripple intend to meet and confer on a potential briefing schedule in regard to the pending issue in the case. What remedies are proper against Ripple for its paragraph 5 violations with respect to its institutional sales of XRP, and respectfully request until November 9, 2023 to propose such schedule to the court for consideration, or, if the parties cannot agree, to seek a briefing schedule with the court on a contested basis, according to the filing. In reaction to the submission, Ripple's chief legal officer, Stuart Alday-Ortiz, described it as a surrender by the SEC rather than a settlement. The crypto business called the SEC decision a stunning capitulation in a statement. Chris and I were targeted by the SECs in a ruthless attempt to personally ruin us and the company that so many have worked so hard to build for over a decade, Garlinghouse said on X, previously Twitter, on October 19th. The SEC's Ripple activities started in December 2020 when the agency filed a complaint against Garlinghouse, Larsen, and the business, mostly over the sale of its XRP coins, which the regulator also alleged were security. A federal court determined in July that XRP, when traded to individual investors, was not a security. It's unknown why the SEC decided to withdraw the allegations over 3 years later, with a trial set to begin in April 2024. Bowie Digital's chief legal officer, Catherine Kirkpatrick, said that abandoning the complaint against Garlinghouse and Larsen might indicate that the SEC intends to appeal the court judgment on XRP as a security, which she said would have had to wait until the trial concluded. Other high-profile people in the crypto field that are being investigated by the SECs include former Celsius CEO Alex Mashinsky and former FTCO Sam Bankman-Fried. The criminal trial for Mashinsky is set to begin in September 2024, while the trial for Bankman-Fried is set to start on October 26. The Commission has also filed civil cases against Binance and Coinbase, two cryptocurrency exchanges. The United States Securities and Exchange Commission, SEC, has dismissed charges against Ripple Labs leaders Chris Larsen, chairman and co-founder, and Brad Garlinghouse, CEO. Plaintiff, SEC, respectfully notified the court of the stipulated dismissal of the SEC's pending claims against defendants Christian Larsen and Bradley Garlinghouse, according to a recent court brief. Notably, the court made this clear in a briefing yesterday by pro-XRP counsel James K. Phelan. The news sparked responses from the XRP community, with Ripple close Stuart Alday-Ortiz commenting on the SEC's decision to drop the lawsuit against Larsen and Garlinghouse. In a statement, Alday-Ortiz said that the SECs made a mistake in going after the company's executives, which led to the company's surrender. Surprisingly, Ripple's chief legal officer referred to the action as a capitulation by the SEC rather than a settlement. Other XRP followers, in addition to Alday-Ortiz, responded to the news. According to one expert, the regulator withdrew the accusations because it did not want to lose for the third time in a row. Remember that on July 13, the court found that most XRP transactions that the SEC claims are securities are not. The court also refused the SEC's attempt to certify an interlocutory appeal. Notably, the court's decision on the April 2024 trial might have been another crucial decision in the case. The dismissal of the lawsuit is a significant victory for Ripple, causing the price of XRP to surge dramatically. According to CoinGecko statistics, the price of XRP increased by more than 10 in the aftermath of the announcement. Interestingly, XRP rose to a 24-hour high of $0, 528, from a low of 477 cents. At press time, the currency was trading at $0, 512, up 6.3 in the previous 24 hours. The SEC first charged Garlinghouse and Larson with assisting Ripple Labs in breaching securities laws via the selling of XRP to institutional investors. As previously reported, the court concluded on July 13 that Ripple's institutional sales qualify as investment contracts, but sales to ordinary investors do not. As a result, the court ordered the SEC's case against Ripple executives for a jury trial in April 2024. With the SEC dropping the accusations against Garlinghouse and Larson, there will be no trial in April 2024. The SEC will work with Ripple to establish the proper remedies for the company's breach of securities laws via its institutional sales. Following the remedies stage, the SEC might launch a complete appeal of the case, contesting the court's findings on programmatic sales and other distributions. Furthermore, the SEC might reach an agreement with Ripple and stop the multi-year legal struggle. So yeah, the agency has not indicated any preparations for a settlement. It seems to be planning to challenge the court's July 13 judgment, which defined programmatic sales and other XRP disbursements to be non-securities. Social media has become a battleground in the ongoing legal battle between Ripple and the U.S. Securities and Exchange Commission, SEC, with some users arguing that the latest court verdict will have little to no impact on the cryptocurrency industry, while others are vehemently to the contrary. An ex-SEC attorney, John Reed Stark, called the recent rejection of the agency's move for an interlocutory appeal by Judge Annalisa Torres a Pyrrhic victory at best for the XRP team in an X post published on October 6. After the trial, the governing body will still undoubtedly appeal the decision, and I believe have a good chance of winning, Stark says, since the judge has specifically deemed her decision as not precedent for the rest of the cryptoverse. Moreover, he disregarded the most recent judgment by Judge Torres as precedent on the issue of whether tokens are securities, saying the court did not hold that offers and sales on a digital asset exchange cannot create a reasonable expectation of profits based on the efforts of others. The former attorney for the SEC specifically stated that the court held that based on the totality of the circumstances in this case, including an examination of the facts, circumstances, and economic realities of the transactions, Ripple's programmatic sales could not lead investors to reasonably expect profits from Ripple's efforts. Emphasis in original. Agree to disagree on the legal impact of Judge Torres' rulings, but you also seem to be saying that XRP uniquely stands as the only digital asset, other than BCC, with judicial clarity as a non-security. Stuart Alderodi, the chief legal officer of the blockchain company, responded to Stark's post. We're on the same page now. Attorney Jeremy Hogan simultaneously listed multiple potential outcomes for the Ripple v. SEC case after the judge denied an interlocutory appeal motion, including the regulator proceeding with a trial next April against the individual defendants and an appeal of the case no sooner than 2025, with an appellate ruling no earlier than 2026. Alternatively, the SEC may settle all litigation against Ripple and the individual defendants at a settlement conference on April 16, 2024, or it may proceed with obtaining a final judgment against Ripple and then appeal.